Ani, Tonin Dabnajnikas, Ukwam Kong Saganin Donjaba, Ninsagod Nishnabe. Greetings. My name is Tony Mandamin. I'm from Ukwamkung. I am Anishinaabe, and I'm going to be talking about the 7 sacred teachings of the Anishinaabe. Those teachings are honesty, courage, respect, love, humility, truth, and wisdom. They used to be called, and they're still called by some, the grandfather teachings. But the last time I had a teaching about them, it was by a group of grandmothers. More recently, they've been referred to as the 7 sacred teachings. Now, there is a painting by Roy Thomas, who's an Anishinaabe artist from northwestern Ontario. He called his painting Indian Law, and it depicts a moose standing on the grass on top of a rocky knoll with pine trees in the background. And I asked him why he called his painting Indian Law, and he explained, if you look at the pine trees, they're straight. That's honesty. If you look at the granite outcrop, that's strength, that's courage. If you look at the grass, that's soft, that's kindness. And if you look at the moose, that's sharing, because we, the Anishinaabe people, depend on the moose for our sustenance. The last 2, kindness and sharing, are aspects of the teaching of love. The other time I came across the 7 sacred teachings, it was just after the decision was issued by the Supreme Court of Canada in R versus Badger. And that was a case that upheld the hunting rights of Treaty 8 Indians. And in that decision, the Supreme Court recognized the sacred value of the treaty. Dan McLean was an elder who testified in the trial on that case. And when the Supreme Court of Canada issued its decision, it accepted the evidence of Dan McLean about Treaty 8. And so when the decision came out, and this was about a year after we had argued the case before the Supreme Court, I met with Dan at a gathering and was talking about the case, and I was trying to explain how the Supreme Court arrived at their decision. And it was a little challenging to translate the language of the Supreme Court justices and law to the perspective of a quite well-respected elder in northwestern Alberta. And I asked Dan McLean, I said, what would be the Indian law that would apply to this case? And he thought for a moment, and he answered with one word: respect. Yeah, I thought about these for quite a while. I'm familiar with the criminal code and Canadian law, and how it says you're not to assault somebody, you're not to steal from somebody, you're not to do this, and if you violate these, that you're breaking the law. But these Anishinaabe sacred teachings are different. They're positive instead of negative. They say, be honest, show respect, have courage. These are positive values, unlike the negative prohibitions of the Canadian criminal laws. And so, as I thought about it, I said, well, how does one live by these laws then? How does it affect one? How does it guide a person? And the more I thought about it, I decided to look back into my own life and see if it played out, how it played out in my own life. And these are roughly, I'll address them roughly in the order that they occurred in my life. And the first is wisdom. I was raised by my grandmother on the Wukwamkong Indian Reserve. As a young child, I had polio, and I had one leg all pulled up. I couldn't straighten it out. They decided when I was about 8 years old that I should have an operation. And the operation would involve my being taken from the Wukwamkong to Sudbury, which in those days was quite a journey because a good part of the trip was by gravel road. And there they would operate, they explained that they would open my ankle and cut my tendon and lengthen it by inserting more material. And the family was very concerned about sending me away. They wouldn't be able to accompany me. I'd have to go alone. I'd be taken by a social worker and a nurse. And then I would be there for about 3 months. So there was quite a bit of fear. And their experience with people going away to a distant hospital like that was that there were times when they didn't come back. And there was a great deal of concern in the family about whether I should go or not. And my grandmother decided the matter. She was a medicine woman in the sense that she treated people. Their prayers always involved, but what her knowledge involved was all of the plants and herbs and medicines that the Anishinaabe people knew of and used. And this operation was something different. She didn't know about this. This was strange and unknown to her. But she thought about it, and she said, I cannot make Tony better by my means, and this is a way that he could become better. He could straighten out his leg, and he could run and play like the other young children. And so, on her decision, I went to Sudbury. I had the operation. It was successful, and I could carry on with sports and other activities that all children like. That was an illustration of wisdom. Wisdom isn't knowing the answer. Wisdom is taking the knowledge that you have and assessing the unknown and coming to a decision on a way to go forward. And that's because of my grandmother's wisdom. My quality of life was considerably improved. So that was wisdom. The next subject I'd turn to would be courage. And it may be known, courage, perseverance, strength, those are all different aspects of it. When I finished grade 10 on the reserve, I was going to be leaving for Schollard Hall, a boarding school in North Bay, Ontario. And my father spoke to me. He explained that my grandmother had been in the Kwemkong residential school and had reached grade 4. He himself had reached grade 6, and I, who had just graduated from grade 12, and I, who had just graduated from grade 10, was the most educated person in the family. And he said to me, "You're the one who's going to have to decide whether you're to continue with your education." So I went to Scholar Hall. I took grade 11 and grade 12, and I wanted to go to a university. So I applied and was accepted at St. Patrick's College in Ottawa. And I went there. It was a wonderful year. I learned a lot. Unfortunately, a lot of it had nothing to do with academics, and I failed. And that was a real shock to me. I hadn't failed in school ever. And the only way I could continue in school was to go back to Scholar Hall and take grade 13, which they had in those days. But if I went to Scholar Hall and took grade 13, I would now be going to school with students who had been 2 years behind me. I suffered a loss of confidence. I was unsure of myself. I was really embarrassed. But I really wanted to go to university, and I had to get through to go to university. So I did go to take grade 13 at Scholar Hall. I got it. I ended up going on taking electrical engineering ultimately at the University of Waterloo, and then much later in life, law at the University of Alberta. And I found something out that if you run into an obstacle and you keep going, the next time you run into an obstacle, it's not that big a deal. And if you keep going, it's easier to overcome. And next time you run into an obstacle, it gets even easier. As a matter of fact, it gets quite easy. I took a year off in the course of taking electrical engineering. Worked for a number of years after engineering before going into law. And out of that whole experience, I learned that perseverance can carry you forward when you think you've hit the end of the road. And that, to me, is what courage represents. It wasn't bravery. It was to keep going even when you were unsure of yourself and you had doubts and all that, and you went anyways. So that's courage. When I graduated from law at the University of Alberta, I eventually opened an law office out at Enoch on the west side of the city. And the Native court workers in Stony Plain Provincial Court heard of my being there, and they were dealing with Indigenous clients, and who they felt needed a lawyer, and they started referring them to me. In those days, they handled the legal aid applications, and they would fill them out, put my name in, and call me up and say, we've got a client for you. And I would go to meet the client, hear what happened, and then go see the Crown prosecutor. And these were days before Stitchcomb, where the Crown is obligated to disclose what information they have to defense lawyers. But things were more relaxed, especially in the rural settings, and the Crown I'd go see the Crown prosecutor, and typically he would take the file concerning my client's case. He'd hand it over to me and say, this is what I've got. And when I went through it, almost invariably, I'd find that my client admitted everything the Crown needed to prove their case. And so I'd go back to my client and I'd say, well, you made a statement to the police, didn't you? And they says, yes. I said, well, did they threaten you to make, or force you to make that statement? Did they threaten you? Did they kind of say they'd go easy on somebody else if you confessed to the offense? And they'd say, no. And I'd say, is there anything? Did you make that statement voluntarily? And they'd say yes. And I would be left with the option, the only reasonable option of going to court with my client, having him agree to plead guilty. We'd get rid of the extra charges that the police had a tendency to load onto the case, and get those out of the way, and then speak the sentence. And I did fairly well in terms of speaking the sentence. Got good results from my client, and they were satisfied with the way things worked out. But I was thinking, well, maybe I should be fighting these cases. I should be running trials and contesting them, and I should be holding seminars on the First Nations, telling people you don't have to say anything to the police. You can insist on speaking to a lawyer, or you can plead not guilty when you go to court. You can have a trial even by jury. But that didn't seem right, and so I didn't do that. And it turned out that the Indigenous Bar Association had been asked to do a paper on Aboriginal people in the criminal justice system for the Law Reform Commission of the day. And they asked me to chair that group, and there was 5 of us. We were all practitioners. We all went to court. We're all Indigenous people ourselves, and we put our heads together, and we came up to the realization that really the offenses in the criminal code, with a few rare exceptions, were offenses in the Indigenous community. What was different was the way they were dealt with. For the person raised in the Euro-Canadian system of justice, the Crown had the power to override an individual. They could invade their home. They could use torture to force them to make statements. They could hold secret trials. They could instruct the judges to come to a certain conclusion. So over the centuries, the Euro-Canadian justice system, which is the English justice system, those back then, developed ways to protect against that. You couldn't use a statement by an individual unless it was voluntary. So if a statement wasn't voluntary, then it couldn't be used in court. A person could plead not guilty, and the Crown had to prove their case. You could have trial by a jury of their peers. All of these measures, you had a right to consult with a lawyer. And all of these measures were safeguards built up in the Euro-Canadian justice system to offset the unfairness if the Crown was able to use its powers. But that wasn't the way that offences were dealt with in the Indigenous community. In the Indigenous community, if somebody did something wrong, because of the close-knit nature of the Indigenous community, it was generally known who it was. So if the person denied doing it, they got a reputation as a liar. And if you get a reputation as a liar in an Indigenous community where everything is oral and where everyone has a good sense of knowing each other, then when you're trying to influence the way something is done, you might make a great argument or a great speech about an issue, and it'll get dismissed by somebody saying, "Oh, he's a liar." And you destroy your own reputation, you destroy your own capacity to influence others. So the expectation is the person will tell the truth. They will admit to what happened. But that isn't the end of the story for dealing with offenses in the Indigenous community. In the Indigenous community, the question really is, what do you do about it? They had no jails. And but on the other hand, somebody had been harmed by the person's actions, and they had to bring things back into balance. And so the effort would go into what is done about it. So there would be an admission right away of the facts. The person would say, "Yes, I did hit him, but he said something that about my family that really hurt me, and that's why I hit him." So, those are all taken into account, and they work out what the resolution will be. So, in the Indigenous community, honesty is seen as being the first step to behaving properly again. And and that's pretty much the conclusion. We were able to, the five of us, were able to correlate that with our own experiences with Indigenous clients, and we're able to document it in historical accounts of how Indigenous people dealt with offenses in their day. So that's honesty. Another virtue is humility. And humility, as a sacred teaching, is an important one. In this respect, with humility, that enables you to listen to others and to hear them. You don't put your own thinking, your own values in the way of hearing the other person and seeing how the other person sees things. And I had my law practice going. I had a one-room law office, and I was in my fourth year. I just finished my fourth year of practice, and this young lady comes in and says to me, "You have to hire me as your articling student." And she was so insistent and persuasive, I finally said, "Well, I don't know if I can pay you, but okay." And that was, her name was Eileen Paulus in those days, subsequently Eileen Sasakamus. And I found that I enjoyed that experience. And I ended up, I was on my 7th Indigenous articling student, on my 7th articling student, 6 of them were Indigenous. One was a young lady who wasn't Indigenous. That was to show I was an equal opportunity employer. And that, and I enjoyed that experience very much. When I was appointed to the provincial court, I got a call from another young lady, name was April Babcock, subsequently Gladue, and she said, "You have to preside at my call to the bar." Now, in Alberta, the practice was that when a law student had finished their legal education and they completed 1 year of articling, then a lawyer makes an application to the Court of Queen's Bench for an order admitting that articling student as a member of the Law Society, at which point they become a full-fledged lawyer. And I said, well, I told her I'm a provincial court judge. You know, this is done by Queen's Bench judges. And she responded, she says, I know, I figured it out. I'm making arrangements for you to join the Queen's Bench judge on the bench at my call to the bar. And so that happened, and other Indigenous articling students got wind of the approach, and next thing I knew, I was hearing one after another joining the Queen's Bench judges in that. Until another one came along and said, well, no, I want to be called in your court. And by this time I had Sootenay Peacemaking Court was established, and I was sitting, and she wanted to be called there. With the result was my calling the Queen's Bench justice to come to my court so we could hold a call to the bar ceremony in the Sootenay court. And that was done. And the legislation was changed so that a provincial court judge could admit an articling student as a member of the Law Society in his or her own right. So when this legislation came into effect, I got a call from, in fact, one of my former articling students was a practicing lawyer for a number of years by then. And she said, I've got an articling student that I want to present and have called in your court to for her call to the bar ceremony. And it turned out the student was from the Saddle Lake First Nation. And I thought about it, and I said, all right, but this is the way we'll do it. I called the chief judge, and I got him to, provincial court chief judge, and I got him to designate the high school gymnasium on the Saddle Lake First Nation as a court for the purposes of the call to the bar ceremony. And so we had the call to the bar ceremony. It was an Indigenous lawyer making the application on behalf of an Indigenous articling student who was a member of Saddle Lake First Nation. I was Indigenous myself. My court clerk from Sootenay came up. She was Indigenous. And we had, in addition to the family members who were there for the call to the bar ceremony, we had 200 high school students to observe the call to the bar ceremony. And I did that at Sootenay later with another student, and still another at Siksika. So And when I got to federal court, I found that there weren't very many, if any, I can't recall any when I started that were in, there may have been some previously, Indigenous law clerks. And the law clerks are law students who will get taken on by federal court judges as their law clerk, and they spend a year in basically the same capacity that an articling law student would be in practice. And then at the end of the year, they get their call to the bar. So I started, I carried on with my practices, and between articling students and law clerks, I've had about 14 or so Indigenous students achieve their call to the bar. And all of that came because the one young lady started me off by persuading me to hire her as an articling, or take her on as an articling student, and because another young lady persuaded me to sit at calls to the bar, even though as a provincial court judge I ordinarily couldn't do that. But that's what humility, that's the benefit of humility, is you can listen to people and you can hear things and you can learn things and do things that you never would have thought of. The next value that I talk about is truth. In my language, deboe. And truth is seeing how it really is. I had been a lawyer for Siksika Nation for many years. And when I was appointed to a provincial court judge, the Siksika asked me to become their, be the judge sitting at Siksika, presiding in court. And so as I'm sitting there, I'm thinking to myself, well, how can I help the Siksika from this position as a judge? And I thought about it and thought, well, maybe helping to deal with drinking and driving cases. No, that didn't seem to be fundamental. And over time, I realized that whenever I had a case that involved serious violence, almost invariably in the background of that individual that was before the court was the fact that as a child, he or she witnessed family violence. And I started thinking about it, and I came across a Siksika story about the worm pipe. And that story involved, there was a young man and who had married a young woman. They were very much in love. They had a little boy. And the young woman got sick and she died. And he was very much aggrieved, very sad about her passing. And he eventually he told the elders that he had to go get her back. And they tried to dissuade him from this notion, but he was very insistent. And they said, "All right, we will tell you how to do it, but you understand it is a very difficult and dangerous undertaking." And so they told him how to travel to the shadow world, and he made that difficult journey. And when he got there, the shadow people were very amazed to see him arrive, and he explained why he had come. And they said, "We'll have a feast to celebrate your accomplishment in making this journey. And when you return, we will give you this pipe the worm pipe to take back in recognition of your courageous undertaking. And they said, you can also take your wife back with you. They said, but you must never raise a hand against her or you will lose her. So he and the wife made the journey back to their tribe, and people were amazed, and he was much celebrated, and all of this. And the family, the husband, the wife, and the child resumed their lives together. And one day in the teepee, when he asked his wife to do something, and she wasn't quick in responding to do it, he grabbed a stick from the fire in the teepee and raised it, and she disappeared. And the worm pipe is one of the objects that's contained in a medicine bundle. And the objects in the medicine bundle all have a story or stories about them. And that was one of the stories associated with the worm pipe. And so I would tell that story in court whenever we had a family violence case, and say that's a teaching, Siksika teaching against family violence. And we ended up developing a protocol. The elders got involved, and we ended up getting more reports. Normally these kind of cases don't get reported. We got more and more reports, and as that happened, the level of violence in the reports started being less and less and less, and the age of the couples got younger and younger and younger until we were getting the new family formations. And a Crown prosecutor took the effort to track these cases and reported to me that in the 2 years that he'd been tracking them, while the number of reports and number of cases went up, violence had gone down, the age of the couples had gone down, all of these which I just said, and we only had 2 repeats. That so Debo in truth is to see things how they are and see what's important, and not to be fooled by other things. And that's a very important teaching these days. Another value is respect. When Dan McLean answered my question about the Indian law that applied in the hunting case, it was a case that involved a treaty Indian hunter who was hunting on unoccupied private land. And Dan McLean had explained, when he said respect, the way I interpreted it was that he said, you have respect for the treaty Indian hunter, and you have respect for the landowner, and then you put the two, with the respect for those two people, you work out what the answer is. And if the land's not being used, then the treaty Indian hunter could hunt there. If it's being used, then you don't interfere with the landowner's use of that land. And I've always, in my days growing up and in my practice, and then later when I was with the court, I've always had the greatest of respect for our elders. Just something I was raised with. I suppose my grandmother was an influence in that, but that was true for any elders in the community. And I was doing a lot of work for the Indian Association of Alberta, which existed back then. And the president of the day had decided that he was going to change lawyers. and get another lawyer in place of me. And the elders took issue with that and made him reverse the decision and keep me as the lawyer for the Indian Association. And I didn't know anything about it. Didn't know that had occurred at all. And when I learned about it after the event, and somebody told me when it occurred, I have to say that I never had been so honored as to receive the respect that the elders had given to me, whom I deeply respected. The next value I'll speak about is love. We have 2 grandchildren, Mia and Arlo. And when they were little, still are, and they would frequently visit our place, and my wife one day said to them, "Who loves Grandma?" Total silence. And then finally Mia says, "Grandpa loves Grandma because that's why he married you." And so the reason I tell that story is because my wife and I had gone to the Indigenous Bar Association conference in Rama, Ontario. And at the time, there was a great deal of dissatisfaction with the federal court and the Federal Court of Appeal over decisions that had been made. And I have a tendency, by that time, I'd been a provincial court judge for about 5 years. And we were getting quite comfortable at Sutana and Siksika, and I was getting comfortable in my other sittings. And I have this tendency to want to jump into fires. And I made the comment to my wife. We were sitting in the lounge and talking, and I made the comment to my wife that I said the place to be is the federal court. The problem is that to be a federal court judge, you have to reside in Ottawa. And she answered saying, "I'd move to Ottawa." Now, she had 11 brothers and sisters, all of whom live in Alberta. Very close family. Many cousins and relations. Our daughter was in Edmonton, and she's prepared to move to Ottawa. A week later, I put my application in to federal court. Didn't hear anything for about 1.5 years, and then I got a phone call asking if I would move to Ottawa, be a federal court judge. And we did so for just over 10 years. And she was willing to make that sacrifice because it was something she thought that I should go ahead and do. So that's how love affected, I guess in a way, not only me, but people I associate with. And so with all of that, this is how the 7 sacred teachings have guided and influenced and shaped the way I've lived throughout the years. And hopefully this gives one a sense of how those 7 sacred teachings are law
that are to be valued and followed to live what we say in Anishinaabe and Bimadzu, a good way of living. Miigwech. Thank you very much.